We've been hearing this a lot lately, well, at least since last week. The theme around the conversation of Idaho's new abortion law seems to be, I don't know. There's a lot we don't know. There's a lot of unknowns. It's an answer we continue to get on a variety of questions, and we ask a variety of people who are supposed to know how Idaho's new laws will work. And sure, there is some time to figure it all out, but still, there are and might be a lot of unanswered questions. And we see those questions every day, like this one. Linda wrote us and said, does HIPAA provide any support for privacy against the new abortion laws, especially allowing family members to sue a provider? Well, Linda hasn't been the only one to ask this question, if HIPAA protections could prevent investigations into illegal abortions. In Idaho, when that law goes into effect later this summer, there might be some new rules in play. HIPAA, the Health Insurance Portability and Accountability Act, does protect the release of medical information, but how far does that go? Is this something that could really complicate Idaho's new law? Joe Paris spoke with a Boise expert on HIPAA and how it could interact with the state's new abortion law.
When Idaho's abortion laws change later this summer, sensitive medical information will be at the center of the conversation. Idaho's law will outlaw almost all abortions, creating a situation where there could be investigations into possible illegal abortions. There are questions. How will that look? Investigating private medical information, like the circumstances around an abortion, can be sensitive and difficult. Some are asking if Idahoans can cite HIPAA protections to avoid investigations if they find themselves in that situation.
HIPAA does not apply directly to the patient. HIPAA only applies to healthcare providers who engage in certain electronic transactions and health plans, including employer benefit health plans. So the patient can't necessarily hide behind HIPAA because HIPAA doesn't cover them, doesn't apply to them.
Kim Stanger is a partner at Holland & Hart Law Firm, where he's the head of the Health Law Group. He explains, HIPAA, the Health Insurance Portability and Accountability Act of 1996, it doesn't apply to individuals. It covers healthcare providers and how they need to protect patient health info.
The provider and the health plan and their business associates would be prevented from disclosing any protected health information unless they fit within a HIPAA exception. And there's different HIPAA exceptions that may or may not apply depending on the circumstances.
So, as Stanger explains, HIPAA does prevent the release of medical records, but HIPAA only goes so far. It's not an absolute block in all cases.
Certainly, if the police or law enforcement or investigator, if they go to court and get a warrant or a subpoena, then HIPAA would allow the disclosure or compliance consistent with the court order or warrant. Although for subpoenas, there's some additional steps that the law enforcement would have to jump through before they could access the information.
If there was a situation where a doctor was brought into court in a suspected case of illegal abortion and no subpoena or anything of that matter has been made to access medical records, that doctor can only say so much. HIPAA protects patients if no exception has been made, like a court order.
Not only may they do it, but they would have to do it under HIPAA. HIPAA would prevent them from disclosing the information unless a HIPAA exception applies. But it's not too hard to satisfy one of those HIPAA exceptions if the law enforcement goes and gets a court order or a warrant that requires that physician to go ahead and make the disclosure.
It's important to note, HIPAA was not designed to be used as a way to dodge investigations. Rather, it's simply to protect information.
It was to protect health information, but you have to balance that against the need of law enforcement to enforce crimes, to enforce the existing laws. And so HIPAA tries to balance that by creating certain exceptions that would allow the law enforcement to access information without court involvement. But aside from those, it always leaves open the option for the court to go, or for law enforcement to go get a court order or warrant, just like they would in any other criminal investigation.
So to summarize, yes, HIPAA prevents healthcare providers from releasing information, but there are clearly defined limits and exceptions.
When it comes to law enforcement officers can get around HIPAA by getting a warrant or a court order or fitting in with one or the other exceptions. So they can't cite HIPAA just to ignore a court order or warrant.
So as we've highlighted in this discussion really since last Friday, there's a lot of unknowns, but we do have the answer now for the HIPAA situation. But we see all your questions every evening here on the 208, and a lot of them we are putting into our file to get them answered. When we talk to experts in the legal and the medical and even the judicial field right now, a lot of them say there needs to be conversations over the next 30 to 60 days to really get all of this flattened out. And Brian, something that we heard from Mr. Stanger there is they're also looking for some guidance from the Idaho Attorney General's office on how specifically to maybe take a look at some of this in court or take a look at how this could be investigated. All of this is, of course, complicated by the fact that there's another state law, the civil enforcement mechanism that we've talked about, allowing family members to be sued. That's still caught up in the Idaho Supreme Court. So whether that gets decided soon or not, we'll find out. But the whole thing is it's very complicated.